Since as an entrepreneur you will be providing a good or a service, you will definitely have to be familiar with intellectual property. Intellectual property is the product of human ingenuity protected by law. To make it plain and simple, intellectual property is the result of what someone is thinking. Whatever you think about is intellectual property. However, not everything you think about is protected by law. This becomes very important as you learn about copyrights, trademarks, patents, and trade secrets. Intellectual property is protected in the Constitution. However, the Constitution only addressed copyrights and patents. Other laws were enacted to include trademarks and trade secrets. Whether your intellectual property is protected in the form of copyright, patent, trademark, or trade secret, it will only be protected for a limited time. A patent grants property rights to the investor for a specified period of time. A utility patent and a plant patent expire 20 years following the original patent application. A design patent expires 14 years afterward. These are the only types of patents that exist. A owner of a patent is called a patentee. A utility patent is the most common type of patent awarded for inventions or improvements to methods, processes, machinery, and compositions of matter. A plant patent is a unique patent right granted to investors of new forms of plants. A design patent is a unique patent right granted to protect the look, not functionality, of an invention. A patent confers or gives you the right to exclude others from making, using, or selling the patented product. This is consistent with the Copyright Clause of the United States Constitution, which grants investors the exclusive right to their discoveries. Trade secrets are secret information that companies have about their goods and/or services. Some examples of trade secrets are soft drink recipes, KFC's 11 spices, and Big Mac's special sauce. Trade secrets can theoretically last forever. That is, it can last forever if the owner of the secret can actually keep it a secret. Trade secrets are unlike patents in an important way. With a patent, the inventor must specifically disclose the details of the invention when applying for a patent. This means that the inventor has not protected the secret of the invention. However, in exchange for this disclosure, a patent owner has a legal monopoly over the property for a specified period of time. So even if others discover the secret of the invention, not a difficult task since patent applications are public record, they are prohibited from making, using, or selling it without the patentee's permission. After the patent expires, then the patentee no longer has a property right to exclude others. A trademark is any kind of name, logo, motto, device, sound, color, or look that identifies the origin of a particular good or service. Trademarks only exist if a consumer identifies it with a particular origin. For example, Diet Coke has been identified by the consumer as a carbonated drink from the Coca-Cola Company. On the other hand, Diet Cola can be associated with any company, so it would not be recognized as a trademark. Existing trademarks can lose their protection if the mark is no longer considered unique by the consumer. That is, if they can no longer associate it with a specific company. If a trademark is being used for a business that provides services, the trademark will be officially recognized as a service mark. Facebook is an example of a service mark. Copyright is the exclusive right of authors to their respective works, to the exclusion of others. Copyright is designed to protect creativity. Copyright extends to any form of creative expression, including digital forms. A work must be original, not copied, and fixed in a durable medium to be copyrighted. A durable medium is a tangible way the information is presented. copyright work is automatically copyrighted upon its creation. However, it is further protected when such creation is registered with the Copyright Office. Copyright protection lasts for 70 years after the death of the author. Examples of works protected under copyright law include literary works, musical works, dramatic works, motion picture and other audiovisual works, and sound recordings. As we wrap up this lesson, consider the following questions. What is intellectual property? What two forms of intellectual property are protected by the U.S. Constitution?